But yeah, so just in terms of introductions, my name's Garrett Wright. I use he, him pronouns, and I'm a supervising attorney at Legal Aid Services of Oregon's Portland Regional Office, and I supervise our housing practice there.
Hi, I'm Leon. I'm a housing paralegal, and I use he, him pronouns. I'm very excited to give this presentation.
So yeah, so we're here today. There's a lot of different topics that, in terms of landlord-tenant law in Oregon. What we're asked to kind of focus on today are kind of eviction basics, including some of the new protections for tenants related to non-payment of rent and other charges, and what happens at court with eviction cases typically, as well as kind of reasonable accommodation requests for tenants that have disabilities in the context of kind of reasonable accommodations when a tenant is being threatened with an eviction. So there's a lot of other reasonable accommodation kind of topics or contexts that could be covered, but for today we're kind of focused really on the eviction context. About LASSO, so we are a nonprofit organization with 8 regional offices statewide. We provide free legal help to low-income Oregonians. Leon and I work at the Portland Regional Office, which is the largest LASSO office in the state, probably about 33, 34 staff right now that work in different practice areas. And our service area covers Clackamas, Hood River, Multnomah, Sherman, and Wasco counties. For folks that live outside of those counties, typically there is going to be either a LASSO or an Oregon Law Center office that provides services in those areas. And so sometimes when tenants contact us, say in Washington County, the office there for tenants to contact would usually be the Hillsborough Oregon Law Center office. But the work that we do, housing practices is one of the largest practices, but I would say the largest practice probably here is our family law practice. That is mostly cases that involve domestic violence. So that could be assistance and representation in contested restraining order hearings, dissolutions, custody disputes, child custody disputes, and again, typically, oftentimes it's going to be matters where there's some domestic violence that our clients are being subjected to by a DV perpetrator. Housing cases, so we do some eviction defense work, but as I'll probably mention at the end, we're actually not kind of primarily an eviction defense provider. There are other organizations, particularly in Multnomah County, that have gotten funding exclusively, or maybe not exclusively, but to really boost their capacity and staff to focus on eviction defense work. So our office does a little bit of eviction defense work, but I would say it's not the primary work we do. So we're often referring folks to other organizations like the Eviction Defense Project at OLC, or Multnomah Public Defenders Community Law, or Commons Law, or the PCC Clear Clinic, all of which have hired staff to do focus on eviction matters. Our office, I would say probably right now we're focusing more on affirmative cases on behalf of tenants suing landlords, as opposed to tenants being sued by landlords. And so that would be housing discrimination, particularly in the areas of discrimination based on a tenant's race, ethnicity, national origin, or source of income, and then assistance with government housing programs. So, tenants that live in subsidized housing, different issues that might arise in that context. Our office also has a senior law project that is through our pro bono office. And there's we have work that we do on issues like long-term care facilities, including residents being ousted from those facilities, and elder abuse issues, government benefits issues like SNAP, food stamps, Oregon Health Plan, unemployment insurance benefits. We have a statewide hotline for those types of issues, and then those matters potentially can then be elevated up to further advocacy within the regional offices. Consumer issues like debt collection and bankruptcy, and employment issues like unpaid wages and discrimination. And so we have specialized statewide programs. There's a few of them are listed here. I apologize. The Wildlife Disaster Relief Program, that program wrapped up last year, so that shouldn't be on there anymore. It's my fault for overlooking that. But we have a farm worker program, Native American program, and a statewide tax clinic program for low-income taxpayers. And then 2 statewide hotlines. Again, the wildfire disaster relief is no longer in operation, but we do have this public benefits hotline that folks can call into. And again, if folks want that information, I'm happy to share that the number and things like that at the end of the training today. So here's the overview for today. What we'll be trying to cover. And I think the first part, I think Leon will take the first part, and then Leon and I will kind of alternate through the topics. So.
Yeah, so this is kind of your typical timeline for a termination notice. So when a termination notice is first received, it has to have certain information included in it, which I think we have a little bit more detailed on later, so I'll circle back to that. But you're given the options to try to settle on the stay, negotiate with your landlord, or provide information to prove that you should, to provide like for a for-cause notice or things like that. You can self-evict, which is an often thing that we see, is they move out before the termination notice is over, or wait to go to receive your first appearance and continue to fight it in court. You'll then get your eviction case filed. You have the same options. And then you have your first appearance, which is actually, while I was prepping for this, realized that's kind of changed, because before, if you did not attend your first appearance as a tenant, you would get a default judgment and ruling with the landlord. I believe now the judge is required to check the validity of the notice and then decide to proceed from there for both non-payment cases and other ones as well. During your first agreement, you'll often be asked to step outside, see if you can come to some form of agreement outside of the court. And then you can ask for a trial. You'll have to file the answer within the same day. And then you have the trial period where if the tenant wins, they get to stay. If the landlord wins, the tenant then has to move in the next 4 days. And then during all of this, prior to the start of the trial, if it's a non-payment case, the tenant has the right to redeem, to make that payment, regardless of what the cure date says. If the payment is made before the trial, or even if you're at the trial hearing and you're like, I have the check, the matter will be resolved. For some of the more like in-depth timelines about when notices will be served, it kind of varies on what kind of notice. Thank you. For a lot of people get really curious about when their trial is going to happen, when they want to see the next notice, and usually it's between, I think, 7 and 15 days after the first hearing is roughly that timeline. And then here are the general termination notices. I think the most common one we see is non-payment, which has a little bit more particular timeline, particularly in subsidized housing, but we can get into that later. You can receive a no-cost notice, which will only happen within the first year of residing somewhere. And essentially, there isn't even any reason. Within Portland and Milwaukee County, it will be a 90-day notice. And then outside of those, it will be a 30-day notice. You have a for-cause notice, which is when a tenant is violating the rental agreement or the law. And then a landlord-based reason, which are a little bit less common. And often you'll see for like, if a tenant's living in a duplex, or if like immediate family member for the landlord is moving in, things like that. When receiving a termination notice, they have to be given in very particular ways. And a lot of times in someone's rental agreement, a usual will state how a property manager will give them. So they have to be either personal delivery, first class mail, which adds 3 days to 3 days to the notice period, and then post and mail if the rental agreement allows. We also have a new law, Senate Bill 1069, which allows a tenant and a landlord to come into agreement. That's to be given after the rental agreement was signed, to serve any kind of notice via email. They still have to do one of the 3 methods above, and either party within it, the landlord or the tenant, can decide to no longer do the email way, and then they both have to agree to it. And then for termination notice within themselves, they have to have very specific information on it. They have to have the date issued, the vacate date. They also have to specify the time, and it can't just say like midnight. It has to give the exact time for it. They have to give information for veterans, I believe, as well as the number for 211. For non-payment cases, they also have to include a new handout, which I can't remember the exact detail on what it says, but it will be a similar thing, and it has to be included both within the within the summons notice and within the eviction notice. They'll have to have a chance to cure, depending on which kind of notice it is, as well as state if they are within, if they are eligible for relocation assistance, which can depend on the county and what kind of notice was served.
So now we're going to shift a little bit to just talk about some of the new requirements under House Bill 2001. So this was the bill that was passed last spring that created some new protections for tenants related to non-payment of rent and other certain charges. It's not any and all charges, but it is basically this is for tenants that are receiving termination notices related to the actual rent that they're paying, but also to like utilities if they have utility payments that they're required to make. Often to the landlord, that would be under a type of charge that would fall under this. Late fees, other types of fees assessed by the landlord. The big exception to this is really damage caused by a tenant to a unit. So if a tenant is alleged to have, for instance, caused $2,000 worth of damage to the unit, damage to the doors of the unit or something like that, that is not covered under these new protections. They are treated, tenants in those circumstances would be kind of in the same situation as tenants with other types of for cause notices for things like, for instance, allegations that a tenant's unit might be too cluttered, or that a tenant's making too much noise, or that the tenant has gotten into altercations perhaps, or arguments with other residents or property managers. So it's important to realize that these protections are pretty broad. They do cover rent, utilities, late fees are the most common ones, and again, but not covering damage to a unit. So for when landlords are trying to terminate a tenancy for rent, utilities, late fees, what they have to do is they have to issue a termination notice that typically is going to be at least a 10-day notice. That's up from what it used to be, which was 72 hours prior to this law. Although there had been some back and forth and changes to that with the various COVID, the early COVID era protections that had existed that were temporary. But now the law is permanently the case that for non-payment of rent, minimum 10-day notice of termination, giving the tenant 10 days to pay, and that's issued if the tenant is more than 7 days late on the rent. Landlords can also issue a 13 days notice if they're more than 4 days late. We don't see this as often, but it is an option for landlords. Subsidized tenancies. So when we say that, we mean federally subsidized tenancies pursuant to the Federal CARES Act, which was passed around the start of the pandemic, and which is parts of which are still in effect. The CARES Act states that tenants in federally subsidized housing are still entitled to a 30-day termination notice for non-payment of rent at least. It's not clear whether that law would apply to other types of termination notices besides non-payment of rent, but we think there is some good case law, including some trial court decisions here in Oregon, saying that yes, at least 30 days for federally subsidized tenants for non-payment of rent. So that would be public housing, project-based Section 8 building, low-income housing tax credit building. Those would be some examples of federally subsidized units. Also, I think we would say it applies to tenants that have Section 8 vouchers for at least for that unit that has the voucher. And then only week-to-week tenancies could be terminated now with a 72 hours notice. So if a tenant gets a non-payment of rent notice and the landlord doesn't know about the new law and is still using the old forms, it's possible they might have a defense if the notice provides less than 10 days for the tenant to pay. So that's one part of the new requirements, a big part, giving tenants more time to try to get rent together to pay. In addition to the 10-day period or 30 days for federally subsidized tenants under federal law, there also is an additional notice requirement. Now, this is for non-payment cases only, but they also landlords have to include this form that we have a copy of on the right-hand side here, notice regarding eviction for non-payment of rent. So this is a notice that there's a template that is, this is language kind of, I think, drawn from the law itself. And this is what is on the Oregon Judicial Department's website. So landlords should be attaching a notice that basically looks like this, or at least contains this information. If they don't attach that to their termination notice, that also could be a potential defense to a tenant. They might be able to get their eviction case dismissed if the landlord did not include this this notice that informs tenants that about there's deadlines involved with their case, that there's rental assistance available and support services that may be available, and calling 211, and that tenants might be able to get legal advice by contacting a legal aid organization. So all that has to be provided. If a landlord creates their own notice and they only provide half of these things as opposed to all of the things, I think again tenant probably has a good argument that's defective, and the case should be dismissed. That doesn't necessarily mean that the case is done forever. I mean, typically when a landlord does not comply with notice requirements like 10 days instead of 72, or doesn't attach this notice here to the non-payment terminations, typically what that would mean is the court would usually dismiss the case without prejudice, which means that the landlord, the case, that current case goes away and is done, but the landlord is not precluded from basically trying to now do their paperwork right and reserve a new notice asking for the same things or making the same demands, and reserve a notice correctly, attach this notice about information to the notice, and then they've cured the defects. So that that kind of second case would be allowed to go forward. So it doesn't mean the tenant is completely free from future lawsuits based on the same allegations. It just means that particular case could be dismissed.
Garrett, there's a
yeah.
question in the chat
Okay.
about whether the eviction notice timelines are different depending on where somebody's at within their lease. Like if it's, maybe a brand new lease, or they've, already had the lease for a year, just if that has any impact.
Sure. Yeah. And there was a little bit of information, and I'm happy to share these slides. Natasha, I can send these to you after the training today if you want to share them with folks. But basically one of those earlier slides that Leon was covering about the types of termination notices. So yeah, in general, in terms of timelines, it does depend usually on the type of notice, but it can depend on the tenant's situation regarding their lease. So if someone is a month-to-month tenant, then again, within like the first year of their lease, they generally could be provided a termination notice with only 30 days notice, unless they're in Milwaukee or within the city of Portland, in which case city ordinances there require a 90-day no cause notice even within the first year of a tenancy. If a tenant has it's their first year of tenancy and they have a fixed term lease for a year, the landlord can still give them a no cause notice before the end of that first year. But basically, if the landlord waits too long and then the tenancy goes past 365 days and now you're into a start of a second year of tenancy, then oftentimes landlords are going to be prohibited from using that no cause option. The main exception to that is where the landlord lives at the property, and basically there are one or two dwelling units. So if it's like a duplex and the landlord lives in one duplex and the tenant lives in the other, or it's a house and the landlord lives in the house in one of the rooms and the tenant lives in another room, and things like that, then the landlord could still give a no cause notice even after the first year. But generally, for things like a no cause notice or a landlord based notice, which Leon was saying, were things like moving a family member in, demolishing the residence, doing major repairs or renovations, selling the unit to someone else that's going to move in and occupy it as their primary residence. those type of scenarios, landlord-based reason or no cause, yeah, typically, you can't be terminated any sooner than when your lease expires. So if you have a year lease, the landlord could decide 6 months and to issue you a no cause notice, but it doesn't terminate your lease early. You still have the rest of the 6 months there until the lease expires, and at that point, then the landlord could proceed on their termination notice if they did everything correctly. However, if you get a for-cause notice, those are notices where the allegation is the tenant has done something wrongful. They violated their lease. They violated the law. Those do and can terminate a lease early. So a tenant does not have a right to live out the rest of their lease term if, say, for instance, they got a notice, midway through their lease saying that, they've allowed clutter to accumulate in their unit, and they've been given what we call like a 30-14 notice, 30-day termination notice with 14 days to cure. If a tenant gets that could be any time during the tenancy. And if the tenant doesn't cure, or the landlord thinks the tenant doesn't cure, the landlord can proceed to court and terminate the tenancy and file an eviction case, even though the tenant's lease still hasn't run out. That would terminate the lease early. Another type of notice similar would be a notice for alleging some type of outrageous conduct, saying that the tenant physically assaulted another tenant or was caught manufacturing drugs in their unit or something like that. That could be the basis for a termination notice that just gives the tenant 24 hours to vacate and no right to cure. And again, that can terminate the lease early. So I don't know if that answered the question, but.
Yeah, I think so. Thank you.
Okay.
There's one other question in here about a no cause eviction. So maybe if you can just go back to that for a second, the parameters around when a landlord can give a no cause eviction.
Sure. Yeah. So it used to be, probably 4 or 5 years ago, I think, is when the law changed on this. But it used to be the case in Oregon, and this is the case in most states throughout the United States, is that the general law had been that, once a tenant's lease expired, the landlord had no obligation to continue renting to them, and they could basically give them a no-cause notice, once the lease expired or right before the lease expired, saying, your lease expires in 30 days and I want you out. Same thing with month-to-month tenants. It used to just be the case that the law was, you're a month-to-month tenant, landlord can give you a certain number of days. I think after the second year was 60 days, so a little bit longer. But the landlord didn't have to have a reason why they wanted to evict you. And it could have been because perhaps, they wanted to raise the rents and wanted to get a vacant unit and re-rent it out at higher amounts. Or maybe they had an issue with the tenant but didn't think it maybe rose to the level of something they could evict them on a for-cause notice. So a lot of landlords would just use these no-cause notices for various reasons. And those cases would be very hard to win, because back then the law essentially was, landlords are entitled to do that. Tenants aren't entitled to remain in their unit. And unless a tenant could prove an affirmative defense, like, well, actually the motive, a motive behind the landlord's reason for giving me the notice was retaliation for me engaging in some type of legally protected conduct, or it was a discriminatory act. The landlord is doing this because, the landlord is racist, and this is a discriminatory act based on my race or another protected status. Those would kind of be generally your defenses to a no cause notice. But about 5 years ago, I'd say 4 or 5 years ago, the Oregon legislature passed Senate Bill 608, which basically for the first time kind of created all these additional protections for tenants that kind of did away with no cause notices, except in very narrow circumstances. So as a general matter, not very many landlords anymore in the state, at least not compared to what they used to, their numbers used to be, can evict a tenant on a no cause notice. So it's very limited now. And the main circumstances for a no cause notice that would be valid would be during the first year of a tenancy. And I imagine the legislature's thinking was basically this is like a trial period where the landlord doesn't really know the tenant, doesn't know what the relationship's going to be like. And so the legislature decided to give landlords this window period of a year, essentially, to evaluate the tenant and decide if they want the tenant to move out, that they can do that without having to give a reason to do it, as long as it's within the first year, before that first year's rolled over into year 2. So you see that there, no cause notices in that situation, the end of the first year of a tenancy. And then one thing I'll note with that is that first year of a tenancy, it includes like a situation where, say, there's just one tenant living somewhere, and they moved in and they've only been there 10 months and now the landlord gives a notice. It also, though, applies to situations where there have been new people added to the rental agreement or to the tenancy, basically. So in other words, someone moves into an apartment as a single person. It's just them. They've been living there 5 years. Now comes year 6. Now maybe a roommate moves in with them, or maybe their sibling or their spouse or partner moves in with them. They get approval from the landlord to add them right to the lease, basically get recognized as being kind of added to the tenancy there. What that does is that resets the 1 year period. So now, even though that tenant's been living there 5 years, in year 6, now, if they have someone move in as a co-tenant, now that's a new tenancy. And so the year clock starts ticking from that new person moving in. So then if you go, now and you're in year 6, you go 6, 7 months in, now that landlord could say, aha, I'm going to give you a no-cause notice. Everyone has to move out because it's created a new tenancy. So anytime you've got a new person moving into the unit, there's a risk that would reset the clock typically. So a tenant could then get a no-cause notice, even though, say, one of the tenants has been there for 30 years. If they have someone new move in, that resets things. So that first year of tenancy part, that's when you can use a no-cause notice potentially. And then the other big exception for a no-cause is if it's like basically like a smaller mom and pop type of landlord situation, I think is the idea behind it. So it's like, landlord has a house, landlord lives in the house, rents out a bedroom to someone else. So it has to be, the landlord has to be living there at the premises as their primary residence, and it has to be either 1 or 2 units. So that could be a house where there's shared bedrooms. That could be a duplex situation where landlord's in duplex A and the rents to tenant in duplex B. That would count as being at the same premises. 2 units at the same premises. So that's the other big exception. And that can be used anytime. So, again, you could be living somewhere 30 years, you're in a duplex, your landlord lives next door, your landlord could give you a no-cause notice. Typically, again, that would be a 60-day no-cause notice. And then the other big new categories that got created with SB 608 was the limiting of the no-cause notices, and then the brand new creation of what we've been referring to as the landlord-based notices. Those did not exist prior to 5 years ago. They weren't a thing in Oregon. But now these got created as part of the law, which basically allows landlords to have a reason that's not based on the tenant's conduct to still evict a tenant. And that can be, like I said, the 4 main reasons are: landlord intends to demolish the property, the unit, or otherwise convert it to non-residential use, like they're going to convert the house to a coffee shop or something like that, or a restaurant. Landlord has to do repairs or renovations, and the landlord believes it's going to be too dangerous for the tenant to stay there while that happens. Obviously, that's pretty subjective, and kind of a hard one to prove either way, unfortunately. The third, another one is if the landlord is selling the unit and then the person that's buying the unit is going to move in as their primary residence. So in other words, the landlord can't just say, oh, I have this 20-unit apartment complex, I'm selling it to some corporate LLC, they're going to be your new landlord, here's your 90-day notice because I'm selling the building. That's not a thing. Landlords can't evict someone based on that. They would have to have sold that individual unit that the tenant lives in to another human being, and not a corporation that is going to intend to move in there as their primary home. And then the fourth cause is the landlord or the landlord's immediate family member is intending to move into the unit as their primary residence. So those are the 4 landlord-based reasons that got created with SB 608. And for those type of termination notices, those are 90-day notices. And then a landlord might have to also pay the tenant 1 month's rent as essentially kind of a penalty for terminating the tenancy if the landlord owns or manages more than 4 rental units in the state of Oregon. So and trying to figure that out, whether a landlord does meet that threshold, is sometimes tricky and hard to do for tenants, and sometimes for us to do at legal aid. But yeah, those are the kind of like the timeline requirements. Anything else on that one?
That was pretty thorough. Thanks.
Okay. And so as part of, so kind of jumping forward again a bit, so HB 2001, so these new right to redeem your tenancy. So that, again, this is for kind of non-payment related notices. So, so this is kind of like compare and contrast. So, it used to be that tenants had only until the expiration of the termination notice period to pay what was due. So what we would see a lot of, unfortunately, particularly prior to the pandemic, with some of the, because there were some protections during the pandemic that came into play, but particularly prior to the pandemic, what we saw a lot of was tenants that got behind on rent, and the landlord only had to give them a 72-hour notice to pay. And if the tenant could not get the money together and pay within 3 days, then that might be the end of the road for the tenant, and they might be evicted, because basically the law was that after that 72 hours, landlords could not be legally compelled or forced to accept the rent money. Even if the tenant came to the landlord on the 73rd hour after the notice was issued and tried to give them payment for everything that was owed, the landlord had the legal right to turn that away and say, I'm not taking it from you. And then the tenant would have to see if there was another defense besides payment to the eviction case. And sometimes there could be defenses, and sometimes there still are defenses, like if the apartment was in need of repairs and the landlord knew about them and hadn't made repairs, that could be a habitability defense or counterclaim against the landlord's non-payment. So there were ways to defend those cases, potentially, again, if it's discriminatory, if it's retaliatory. So there were ways potentially to defend those non-payment cases, but sometimes tenants just would not have those defenses. And if not, then that would mean that the tenant's attempt to pay after 72 hours was not by itself a defense, and coming to court with the money in hand or telling the judge you have the money would not work as a defense, and the judge would evict somebody. Court judges routinely evicted people all the time for not having everything paid within 72 hours. So it's very harsh. So what is one of the major new components of the protections under HB 2001 is this new right to redeem. So in other words, you the tenant, if the landlord is demanding, again, if they're trying to terminate you for rent or utility charges or late fees, for instance, all of those things, the tenant has not only just the 10-day cure period under the notice, the termination notice, to pay. And if they do that, then if they pay within the 10 days, then that should hopefully mean the end of it, and that the landlord doesn't proceed with an eviction case because the tenant's cured within that period. The right to redeem means that not only can you cure within that period, you can also cure the case and get the case forcibly dismissed against the landlord's will, so long as you pay everything that's due, that's stated in the notice that you got, before the trial ends in your case. And so if you're looking at this calendar here, you see kind of someone gets a termination notice as early as probably the 8th of the month if the rent was due on the 1st, because 7 days out is when they can issue the termination notice. Then they gives 10 days. And those are calendar days, not business days, 10 days to cure. After the 10 days, on the 19th, that's when the landlord can file the FED, forcible entry and detainer eviction lawsuit, in court. And then the case gets calendared, and I think we'll talk about this. I think we'll have another slide on this, but and the non-payment of rent cases get calendared basically 2 weeks out instead of 1 week out, as it is with most cases. So 2 weeks out from when the tenant case is filed to when the first appearance is, and then the trial in the case also gets set out. I think it's a minimum of 2 weeks out, typically for trial in a non-payment case. So that basically gives the tenant, if the tenant is behind in rent and knows they're behind in rent, for instance, that gives them close to 2 months. And sometimes longer depending on the court schedule, because sometimes the court, even if they could by law schedule a trial, say on the 19th day of the second month as the earliest, there still are sometimes calendaring delays and issues with the court just not having capacity to hear so many cases. So sometimes things get pushed out 2 months, 2.5 months, 3 months before the trial is. And so that gives the tenant much more time. Instead of just 3 days to get the rent together or rental assistance together, they have, close to 2 months on average, 1.5 months, 2 months on average, probably, to get rental assistance. And if they have that assistance in hand, and they can give the landlord a check for everything that's demanded in the notice, then the court is required by law to dismiss the case, even though the landlord might kick and scream and protest. That's what the law says. The tenant has the right to redeem by paying everything that's due in the notice. One of the issues that's come up a little bit is sometimes, like under this situation, for instance, if the tenant, if say the first month is here is February, and the second month on the calendar here is March. If the tenant doesn't pay February rent, they get a notice for non-payment of February rent. The landlord files an eviction case for February rent. Now the case goes into March and trial hasn't happened yet. Now the tenant owes March rent. And if the tenant doesn't pay March rent, what could happen? Well, the landlord could try to amend their case to try to include, to get the court to allow in the March rent, or what could happen is the landlord might just be forced to have to issue a new notice now for the March rent, and then start the process all over again for March. And so, you know, those are two possibilities. But again, this is much better than the way things used to be. And it does give tenants a little bit more time to get rental assistance. And I will just say one last thing to clarify is it is the money that has to be paid. So we got questions sometimes from folks that, you know, questions like, well, I have a promissory note from this nonprofit that says they will pay the rent, but they don't have the check ready yet. That doesn't count. That's not gonna count as payment under the law. The tenant actually has to have, you know, check, money order, cash paid to the landlord before the trial happens and ends in their case. So they could show up the morning of the trial with a check for everything in the notice and give it to the landlord, and that should get the case dismissed. But it has to be the actual payment, not a promissory note. The other part is that landlords are required under the law to reasonably cooperate with rental assistance agencies. So if a landlord were, for instance, to refuse to sign or provide a W-9 form or provide a ledger or things like that, that are kind of basic things related to rental assistance programs, I think that could give potentially a tenant a defense to a non-payment case. They would have to prove that the landlord basically was being uncooperative at trial to get their case dismissed, but that is a possible defense. And then lastly, there's a note here. The landlord could charge a filing fee to a tenant. So in other words, the idea is that landlord, when they file their eviction case, they typically have to incur a cost of a filing fee, which I think is $88. So the law does allow the landlord to still collect that because the landlord's out of pocket that filing fee after they filed the case, but it can't be a prerequisite for dismissal. So in other words, if the tenant can't afford to pay the $88 filing fee, court should still dismiss the case. But what could happen is the tenant might see in their ledger or their next rent statement a demand from the landlord. You know, now we're in April. Yeah, you paid me everything you owed for the past 2 months, last month or whatever. In court, you gave me all the money, but you didn't pay me the filing fee, and so now I could still charge you the filing fee that hasn't been paid yet. And if you pay me, you have to pay me the $88. And so, you know, and then if the tenant doesn't pay that, that could be the basis for a new eviction case based on not paying the filing fee. Sorry, did anyone have other questions on that?
Yeah, there's a lot going on in the chat, and some of, I realize we're not getting to everything in the chat, and we'll do our best to record the questions and get to them at the end of the training, or try to put together some information to follow up afterwards. But there is, I think, a pretty relevant question around if a landlord accepts partial rent payment during that eviction period, what does that do to their eviction process?
That's a good question. I think that probably, you know, it used to be the case that landlords are probably advised not to accept any type of partial payment and to refund, basically return the partial payment. I would imagine it may make a difference where in the process things are. There is a whole statute that talks about landlord waiver and partial payment and what landlords have to do if they get a partial payment. So it's a bit probably too complicated and lengthy to go into during this presentation, but you know, if folks have questions, I can follow up with the exact citation to it. But there is a law, actually a couple of statutes in the Oregon residential landlord tenant law that talk about partial payment and whether landlords waive the right, at least for that month. So typically like a partial payment, like rent is due in January, it's $1,000, tenant pays $500, landlord accepts it. That could be a waiver for the landlord's right to evict the tenant for January rent. Now that doesn't affect February rent, and the tenant tries to do a partial payment in February and the landlord refuses in February, landlord can probably proceed with an eviction case in February. But there may be a waiver if in January the landlord took the partial payment and didn't, like, I think you have to, in order to preserve your right to move forward with an eviction and not waive it on that month, I think the landlord has to do something like have a written repayment agreement with the tenant that makes it clear the landlord's basically accepting this as a partial payment, not as full payment, and not waiving their rights. Or the landlord has to refund the amount due, I think, within 10 days of it being given to the tenant. The interesting question about whether or not, you know, could a landlord accept partial rent payment after the notice has after the case has been filed in court. Again, typically landlords would probably be told by their lawyers not to accept payment because they didn't have to. Now, now landlords can accept payment. So, and sometimes are required basically by the court to accept the payment essentially, or if they don't accept it, have their case dismissed. So I would imagine you probably are going to still see a lot of landlords refusing to accept partial payments during this period because of concerns about waiver. But again, if and the law doesn't allow a tenant to get a case dismissed just because they made a partial payment in terms of the HB 2001 protections. HB 2001 just talks about if the tenant, if you get a termination notice that says you owe $1,000 for January, as long as you pay $1,000 sometime before the trial, then that case should be dismissed. So I don't know if that answered that question, but.
So the eviction can still move forward if the landlord does accept partial payment is kind of what I'm hearing.
I think that's a possibility. I mean, I think a tenant could try to make some type of waiver argument, but I don't know if that would be successful or not.
Okay, thank you.
Other questions or? Should I move to the
Yeah,
next
there's
slide?
a lot of questions in here. Let's see.
Okay.
If a landlord accepts a promissory note, but the payment is delayed, can the landlord request an eviction? Which I think you already answered this, and that a promissory note is not the same as payment.
It's basically meaningless. It's legally meaningless, unfortunately.
Yeah.
It's not the paper it's written on.
And then there was a question around whether or not any of these tenants' rights apply to folks living in foster care homes or group homes. I don't know if you've had experience with that.
That's a good question.
In my experience, they don't apply because it's a completely different business model which has its own kind of contractual relationships. But yeah, I was just curious if you had interfaced with those systems.
Yeah, not very much. Definitely not foster homes. I don't think we've seen a lot. I haven't seen any cases. I mean, typically you have to have like a rental agreement with an agreement to pay rent. Or some type of subsidy that's being provided to assist the tenant with paying rent. I do know Chapter 90 of the Oregon Revised Statute, which is the residential landlord tenant law, has certain exclusions, but there are also other types of housing that are included. So like group recovery homes are, I believe, included within Chapter 90, but there are some differences in terms of types of notices. There's like drug and alcohol free housing that's covered under Chapter 90. But again, there's some certain exceptions to the law where, for instance, landlords that run drug and alcohol free housing can evict someone with like a 24-hour notice for using drugs or alcohol, for instance. So, but yeah, I'm not sure. I mean, I could look into that further, but I mean, I think if someone's living somewhere and they are making a rental payment for a space, I think there's probably a good argument that that Chapter 90 does apply. There are other types of residential situations like assisted living facilities that are generally outside, I think, of Chapter 90 and have their own procedures and administrative rules through like DHS and things like that. So,
thank you.
Yeah. But I just want to be cognizant of the time. I think we have till 2:30. So let me just move to the next slide, if that's all right. Or
that's great.
Okay. Forcible entry and detainer eviction process. So FED cases typically go very fast, less than a month from start to finish. So landlord issues the termination notice. As we talked about, after expiration, the FED eviction case is filed in court. After it's filed, tenant is going to receive a copy of the summons and the complaint to appear in court within 7 to 15 days, generally, again, depending on the type of case and how backlogged the court might be. And then we get to the first appearance. This is the first time anyone, both sides basically are supposed to appear in court. If the tenant doesn't appear, the landlord automatically wins. As Leon was saying, there are some new requirements now that judges have to kind of review the pleadings a little bit more in depth than they used to grant a default judgment. But I think Leon's going to kind of take it from here with the first appearance and some of the other processes.
Yeah. So I think prior to 2024, if a tenant did not attend a first appearance, they'd get a default judgment. I believe the judge wouldn't have to even review any of the things given. It would just automatically be in favor of the landlord. Now it's a little bit different, where the judge has to review the notice, make sure that it's facially valid, and kind of go through the facts. and it still is always, you know, could always send first appearance and be there. And you're able, if a judgment does happen, if a tenant has not attended, you can give some reasons why you potentially missed. It is a little bit hard, but if you had like illness, transportation problem, disability, language barriers, you can then kind of redo your first appearance. And then in a first appearance, either the tenant or the landlord will be asking for a trial. There will be a filing fee. As Garrett said, it's about $88, but you can request, if a tenant is filing, a waiver application depending on what your income is. You have to file and answer the same day, and most of the time, at least for Multnomah County, they'll explain how to do that and have some assistance for it as well. Usually the kiosk desks are very helpful. Typically, the trial will be within around 7 to 15 days, although it really depends on the capacity of the court. Like a good example is after the ice storm, there was a really big kind of delay in when things were being planned out. So we'll give a longer timeline, so that can affect it. It's always, it's usually going to be just a judge. There's not going to be a jury. And then the losing party within an FAD case will usually pay the other side's court costs and attorney fees. Sometimes there can be a voluntary dismissal, such as if the tenant self-evicted, so they voluntarily moved out prior, if they have already given rent, or have been informed about any legal defects with the notice that were given. During all of this, what a landlord will have to prove is that the termination notice was valid. It had all the correct information. It had all the requirements of the veterans notice, rental assistance programs, if applicable, that handout for non-payment cases, that it was served in a valid way. I think a lot of times you'll see, you can check if, particularly around mailing, there'll be a receipt for it to prove that. Sometimes people take photos of when it was posted on their door. If the notice is for cause, if it was from some kind of some behavior by the tenant, proof of that behavior, and if the landlord fails to, if the landlord fails to introduce the termination notice or provide a testimony, especially if it's for behavior and it's been reported by another tenant within the building, they'll need another tenant to give that testimony. The landlord can't really just be like, well, the other tenant said. So if they cannot do that, then we'll move on to an involuntary dismissal. If a tenant hasn't raised a defense or a counterclaim, they don't have anything to prove. I think most of the time, just proving that the notice was given invalidly, did not have the correct amount of information. And then they can raise a motion to dismiss, a motion for judgment on pleadings, and then a motion for involuntary dismissal to close the landlord's case. So if outcomes for an FAD trial, if the landlord prevails, as judgment for possession, the tenant has 4 days to move out, and the landlord will be awarded court costs, attorney fees, if they're represented. It is important to note that the landlord can't move out the tenant. They will have to have a sheriff come do it. That is also something that doesn't have an exact timeline. Same thing to the court. It depends on the capacity of the sheriff, but it will at least be 4 days. If a tenant prevails, and they weren't represented, they will simply dismiss the case without awarding any fees or costs to the tenant. If they were, then the court will award the tenant forward costs and attorney fees as well. So stipulated agreements are something that we see so often, and they kind of be a double-edged sword because they require particular behavioral obligations on a tenant's behalf. So if a landlord and tenant agree to resolve case without a trial, through a stipulated agreement. There's lots of ways they can do that. Sometimes it'll just be a move out agreement. You know, they give the tenant a month or 2 weeks to move out without moving forward with the case. Could be for behavioral conduct, such as noise complaints, to no longer be doing those behaviors. And conclude an employment plan if it's for non-payment cases, things like that. And the agreement will only last for 6 months. If the tenant complies with the stipulated agreement during the 6 months, the case is dismissed. If the tenant does not comply, the landlord can obtain a notice of non-compliance, which can then lead to an automatic judgment of eviction, which is that kind of strict behavior. So within those, if the tenant is late on a payment, ends up engaging in those same behaviors again, can be a very quick eviction process after. So if they did not use a stipulated agreement, then the case will be set for trial and then continue moving forward. But this is something that you could see throughout most of the eviction process within receiving a termination notice within the first appearance, such as when they offer that mediation or just outside to see if you can come to some agreement, things like that. So that declaration of compliance within 6 months to obtain immediate judgment, the tenant can have some arguments. I think a common one was the agreement was unconscionable or not made in good faith, that the tenant was not aware of the strict requirements that it had, or the actuality of what the agreement would be. For subsidized housing, there's a couple other things that, you know, the non-compliance is not a good enough cause for eviction that will be an often one. There's also if the landlord prevented the person from complying with the agreement, as well as particularly for non-payment, didn't allow the tenant to tender rent and things like that.
And I'll just say, I think there's a typo on this, which I'll correct before I send around, but I think that first box is supposed to say tenant did comply with stipulated agreement. And then the next one is landlord did not comply with the agreement. So I think, you know, the landlord alleges tenant said they would pay me $500 by March 1st. It's March 2nd. They didn't pay it to me. A defense to that could be, well, no, tenant files a request for a hearing, says, actually, I did comply with the stipulated agreement. I came to the office. I gave the landlord a check for $500 and they took it, and they're just lying about what happened, right? And then the judge would have to decide kind of, you know, who's telling the truth about the situation, who's more credible, and those type of things. But that's a typo there. It should say tenant did comply with the stipulated agreement, not the lease agreement. Sorry about that. And then I'll just note the non-compliance does not constitute good cause. Basically, what that argument would be is if someone's in federally subsidized housing like public housing, project-based section housing, low-income housing, tax credit building. For example, there's a good court decision that basically says that that the terms of a stipulated agreement have to be ones that would constitute good cause for eviction under federal law. So in other words, some type of like rinky-dink minor violation should not result in the tenant being evicted, even though they agreed not to do it. So for instance, if there was something in there that said, you know, I don't know, tenant agrees that, they will have their trash out on the curb by 5 p.m. every week, and the tenant got their trash can to the curb at 5:01 p.m. That would be probably a very trivial violation of the agreement, arguably, that, tenant could say, this is just so minor, such a minor violation here that I shouldn't be evicted for it. So.
So afterwards, if the landlord obtains a judgment for possession, they'll be issued a notice of restitution. This is very similar to prior if a tenant loses an eviction case. They have the 4 days to vacate. They can only be moved out by the sheriff. So the sheriff is the only person that can physically remove the tenant and change the locks. Unless you don't know that, the landlord cannot do that. And yeah, so after notice of restitution, they have to get a writ of execution as well to then continue this process. So after the trial, attorney fees and costs. Sorry, was this my slide or your slide, Garrett?
Oh, I thought it was yours, but I'm not sure. I'm sorry.
Not even. You could go ahead.
Oh, okay. Sorry. So the winning party may file a supplemental judgment for their reasonable attorney's fees and costs if they were represented by an attorney. If the tenant wins, the fees can sometimes be negotiated as a means of reducing a tenant's back rent if they owe rent, for instance. The landlord wins, there's the possibility of being sent to collections and are entering into payment plans with the landlord. The judgment will have a negative impact on tenant's credit score and potentially their future ability to rent. In other words, even like with a non-payment of rent case, say a tenant owes $5,000 in back rent and they lose their case, they don't get rental assistance, they don't prove their defenses, they lose, and the landlord had an attorney. The landlord does not get a judgment in the eviction case for the $5,000 in back rent. They still have to file a separate, either go to collections or file like a case in small claims court against the tenant to get a judgment for the rent. But what the landlord can get is a judgment for their attorney's fees and court costs. And that can still be sometimes. I mean, we've seen cases where it's in the thousands of dollars, and particularly if the case gets heavily litigated, goes all the way to trial, and maybe there's been motions filed by both sides. Sometimes you're talking about, tenants sometimes being hit with $5, $10, $15, $20,000 in attorney's fees at times. I mean, there's a case that was reported a few years ago where a tenant got hit with $100,000 in attorney's fees in an eviction case because there was so much activity that happened back and forth in the case throughout the life of the case. The tenant had to pay six figures to the landlord just for the attorney's fees. So. After trial, set aside and expungement. So eviction judgments can be set aside and sealed by motion. This is a relatively new provision in the past few years. It's about 3 years ago. Set aside and seals available for all eviction judgments that occurred between April 1st, 2020 and February 28th, 2022. That's kind of regardless of what the basis of the eviction was, as long as the tenant does not owe a landlord money under a judgment. So this was a provision that was part of some of the early COVID era related protections that currently is still in effect. And it's also available for any eviction judgment more than 5 years old, or for any eviction filing where the tenant prevailed in the case or was dismissed. And there's a form that I think on our website, one of the websites that we maintain along with Oregon Law Center is called Oregon Renters' Rights, and we have a section on eviction expungements that includes a packet of information about how to expunge your eviction, as well as I believe it has sample forms that the court uses, or the tenant can go to the courthouse themselves and get a blank form to fill out. They're relatively straightforward and easy to complete, all things considered in landlord-tenant eviction proceedings. This is one of the easier things probably for a tenant to try to do without an attorney, but sometimes there are probably tricky situations that might come up under this law where it may not be as clear. Helpful tips. So this is information about where participants go to court in kind of Multnomah County and Clackamas, which could either be at what's called the Justice Court or the Circuit Court. A lot of evictions are filed in the Justice Court in Clackamas County. Dress code, business casual, we'd recommend. Interpretation services available. Yes, there are theoretically interpretation services that should be available. But if it's a language other than Spanish, then a participant would strongly recommend participants to request those services in advance of the court date, because the court has to do scheduling with their interpreters for other languages. That's some more information there about the rule no later than 4 judicial days in advance of the proceeding. That's kind of basically 4 business days. So try to make that request early. And there's more information on from Multnomah County anyway, on their programs, on that link there about interpretation services. And then I know we have a little bit of time left. I will try to talk about reasonable accommodations and modifications in the context of eviction cases mainly. So reasonable accommodation, as folks may already know, that's a request to a change in the landlord's rules, policies, procedures, or services that's requested by a tenant so the tenant can fully use and enjoy the dwelling. So some examples could be, for instance, a service animal or an emotional support animal in an apartment complex that actually has a no pet rule. And so every other resident basically, or generally residents can't have pets, but if you are a tenant with a disability and you have a service animal or an ESA, you should be able to get an exception to that no pet rule for you as an accommodation for your disability. And you may need to provide some, supporting documentation from a medical provider, for instance, if you have a disability that's not readily apparent to the landlord or readily visible to the landlord can ask the tenant for some verification of the disability from a third party. But generally, once that's provided for something like, say, that should be something that the landlord should be doing, allowing a resident to have a service animal or an ESA. Additional time to clean a home. So, for instance, landlord comes and does an inspection of the unit. They say that the unit's really cluttered. It's a fire hazard. There's going to be, the windows are blocked with belongings, things like that. They might issue the tenant a for-cause termination notice, perhaps saying they have 14 days to cure. And if they don't cure within the 14 days, they'll be evicted, and the eviction could be filed after the 30th day. That's, again, a 3014 notice, what we call those, or 3014 notices. So in response to that type of notice, a tenant or their advocate potentially could make a reasonable accommodation request that the tenant be provided with more than 14 days to declutter their unit or to get services to help with decluttering their home. A reasonable modification is a little bit different. It's a modification, a physical modification, basically, to the structure of the dwelling unit that's requested by the tenant, and generally at the tenant's expense, so the tenant may fully use and enjoy the dwelling. So, for instance, a mobility ramp into the apartment complex or into the tenant's unit, or shower or bath handles, widening doorways for wheelchairs, for instance, things like that are kind of physical modifications. A landlord that refuses to request a reasonable accommodation could be unlawfully discriminating on the basis of disability. So landlords, have to, or should be being very be aware of that. A denial of a request could mean the tenant might have the basis to either sue the landlord in state or federal court for violating fair housing law, or to file an administrative complaint with HUD or with the BOLI, the Bureau of Labor and Industries, for violating fair housing law for denying a reasonable accommodation. Now, again, what a court or an administrative law judge determines is reasonable and unreasonable is, often fact specific. And so, but that is the risk to a landlord. If they deny a request, there could be litigation or administrative complaints against them. In the context of termination notice and evictions, I just want to talk a little bit about what tenants might be able to do if they get a termination notice or have an eviction filed and they have a disability. So here's some examples of potential options that may apply. Requesting that a landlord rescind the termination notice or dismiss the FED case. For instance, the landlord alleges the tenant was engaged in conduct that violates the rental agreement. So if the conduct was caused by or related to the tenant's disability, the tenant could try to ask that the notice be rescinded. Typically, the tenant would also want to inform the landlord about what they are now doing that would enable the tenant to not violate the rental agreement again in the future, such as being on new medication and or enrolled in therapy or treatment. So, for instance, a tenant is accused of making really loud noises in the middle of the night that's disturbing other residents. But the tenant has a physical disability that makes it difficult for them to move throughout their unit without making noise, and they need to use the bathroom in the middle of the night due to their health conditions and things like that. That could be the basis, essentially, to say, this conduct that's alleged that is a lease violation was actually something that was caused or related to my disability as a tenant. And I'm asking that you drop this case, or that you enter into an agreement or a stipulated agreement, or you give me more time before you file an eviction case. And typically, though, if the behavior is something that violates the rental agreement, the landlord doesn't have to agree to allow the tenant to continue to engage in that type of lease violating conduct. So that's why there's this second part here, that typically when I'm doing a request like this, I'm also trying to provide information to the landlord or their attorney to say, and the tenant is in treatment, or the tenant is getting this service, or the tenant is taking a new medication, or something that basically kind of might address the landlord's questions or concerns about whether the tenant is going to keep engaging in the same behavior or not. Requesting that a landlord provide a tenant with more time to move. So sometimes landlords won't agree to not evict, but they might say, well, we'll give you another 30 days, or we'll give you 2 months to move out, or we'll do some type of agreement that gives you more time than you might otherwise have if the landlord had just filed an eviction case. And then here's a couple other examples, requesting that a landlord transfer a tenant to another unit or property. So again, kind of using the noise example. And I had a case like this recently, actually, where that was part of the request, was that the tenant be moved to another property, hopefully to a ground floor unit, because there were allegations that the tenant was causing noise and the tenant below was being disturbed by it. So there weren't any ground floor units available in that tenant's building, but there were, but the landlord owned other properties. So so the idea was try to move the tenant somewhere where potentially, if they're still engaging in some of that behavior, like involuntarily creating noise, that it's not disturbing the person below them anymore. Requesting the landlord make other changes to policies and procedures. So, I've seen situations where the tenant, may have, due to a disability, they may have a difficult time with certain in-person interactions, or there may be a particular property manager that kind of maybe kind of getting under the tenant's skin, or that may be exacerbating some of the symptoms of a tenant's disability, mental health disability, for instance. We've made requests that, tenants be allowed not to have to personally interact with those managers anymore, and that any communication has to be done by writing or email or things like that. So the tenant doesn't have to keep seeing and being in kind of having in-person interactions with that manager anymore. And we have had landlords agree to that and grant those accommodation requests. And that can also to minimize risks that a tenant could be evicted for something like an allegation that the tenant's being hostile or verbally abusive to a property manager, which could be sometimes the basis for termination of tenancy, harassment of the manager or something like that. Requesting that a landlord permit a tenant to make reasonable modification to their unit. So this would be like, so again, like kind of like that noise example, perhaps one option might be for that tenant to try to have some soundproofing installed in their unit to minimize the noise coming out of the unit. Under fair housing law, tenants are generally the party responsible for paying for the cost of reasonable modification. But if the tenant lives in federally subsidized housing, then the landlord is the one who's typically required to pay for the modification, so long as it does not pose an undue financial or administrative burden for the landlord. And that's this federal law from 1973 called the Rehabilitation Act, states that federally subsidized landlords have to pay the cost. Now, again, it's gonna be a case by case analysis, right? And if the cost, say, for soundproofing a tenant's unit is $500, and it's a landlord that has millions of dollars worth of properties and owns 50 buildings throughout the state, and owns buildings in California and other, they're probably going to be held ultimately by a court to be like a party that, like, $500 cost for modifications likely going to be held, I would imagine, to be a reasonable cost. On the other side, on the other hand, if it's like, if it's going to cost $50,000 to soundproof the unit, and it's a mom and pop landlord and they only have one rental unit and they only make $500 a month from their rental unit, that's probably going to be, under the circumstances, determined to be unreasonable for that particular landlord to have to pay for the modification. So sorry, some of this may have been a bit rushed, but this is some more resources here. Again, Oregon Renters' Rights is a good website, has a lot of materials. Most of the materials are up on English and Spanish, and some of the other materials, like the HB 2001 materials, we have been translating and trying to get into other languages as well. Oregon Law Help's another great site, just got recently redesigned by the Oregon State Bar. And then Legal Aid, our kind of main website there, is lasoregon.org. And then lastly, I'll just mention, again, as I said at the start, our office does a little bit of eviction defense work, but it's really, we are kind of, the work that we do in our current priorities are really more oriented around affirmative cases. So doing fair housing litigations against landlords engaged in discrimination, doing cases, habitability cases, particularly cases where the family has BIPOC children in the household and they're at risk of some type of serious health impacts. health and safety risks to the children. Those type of habitability cases, are other kind of priority cases in our office for us to go after landlords and sue them. And then kind of other cases involving kind of, systemic issues, policy issues, cases involving, closures of entire manufacturing home parks, for instance, things like that. That's kind of where our current priorities are. So most of the time, if it's an eviction case, even if we're able to speak with someone and give them advice, typically we're ultimately going to be referring that person, if they want representation in that eviction case, to other providers. Kind of the main place we send folks to is the Eviction Defense Project. They also do a good job triaging cases, so they're kind of the good first point of contact, I think, for a lot of tenants, because even if they can't assist, they might be able to connect someone to Multnomah Public Defender's Community Law Project. They might be able to connect someone to Commons Law or to the PCC Clear Clinic. There are also private tenant attorneys as well that represent tenants. If they think a tenant has a meritorious defense in an eviction case, they might agree to represent a tenant on a contingency fee basis, where typically the tenant either pays a low amount as a retainer or doesn't pay anything at all. And essentially the tenant attorney is depending on winning the case to get attorney's fees from the landlord or through a settlement, stipulated settlement with the landlord. But yeah, so sorry again that some of that was a bit rushed. It's 2:18. Let me exit out of here real quick. So yeah, so do folks have questions? And also, I don't want to speak for Leon, but I'm happy to stay on a little bit longer than 2:30 if that's possible in this space. I don't have to be anywhere right away. And again, I'm happy to follow up with folks too, one-on-one afterwards at some point.
Let me jump in real quick. There was a couple of questions earlier on that I didn't bring up because they were sort of on different topics, but one of them was around who pays for bed bug treatment. And I know you have a really handy flyer on that, but I don't know if you could quickly kind of go over like how that works.
Yeah, so it's one of those things where it's a bit complicated because it actually depends on where you live, because different counties have different ordinances and laws related to this. So what is the case in Multnomah County is not necessarily the case in other counties and things like that. I'm happy to share send around the flyer that we have. But let me take a look real quick.
And if you want to share that with me, I can
okay.
share that out with to all the case managers and personal agents for the TD system.
Right. Yeah, let me see here. But yeah, I can look for that if you, I don't know if you want to go to the next question, I can then circle back to that one. But
the other one was just around when a landlord can raise rent, and there was a situation somebody had where they felt like the raising the rent was connected to a tenant receiving rent assistance and then the landlord wanting to increase the rent costs. But I know rent increases are governed by laws, and so that can't just be, up to the landlord.
Yeah. So let's see. Sorry. So with regards to rent increases, yeah. So generally, the law that typically is going to apply is ORS 9323, and so that talks about rent increases. And again, this was part of some of the changes that happened about 5 years ago with SB 608, which was it kind of created, ended a lot of the no cause notices and created kind of what we call, just cause protections from evictions, where landlords generally have to have a reason now to evict a tenant. And then it also did what some folks might call rent control or rent stabilization. I would call it more of like an anti-rent gouging law, because it is still quite high. I mean, basically under the current law, landlords can increase a tenant's rent by up to 10% every 12 months. So that's can be pretty steep. Other places that have rent stabilization, like New York City, where I worked for like 10 years, sometimes there, like the rent increases permitted are like 1% or 2% in a 12-month period, or can be very low. Or sometimes there's been rent freezes where landlords have been told you can't collect any rent increase at all the next 12 months. So, but yeah, in Oregon right now, the max is now 10%. It used to be a little bit different, but the legislature changed that last year to kind of put a firm cap of 10%. And that's kind of regardless of what the consumer price index is. What we saw last year was we had a lot of inflation. Consumer price index was really high. That had been a part of calculating the rent increase. And I think it was like tenants last year got rent increases of like 14.2% or something like that, I want to say. So pretty high. Now it's capped at 10%, and landlords can only take an increase once every 12 months. So they can't try to break it up into chunks or whatever. They're limited to one increase in any 12-month period, no more than 10%. But there are exceptions to that. So the big exceptions are that if the property, let me bring it up real quick. If the unit is basically an affordable housing unit, and essentially the rent increase is not affecting the tenant's share of the rent, or the rent increase was required because of some requirement of like the subsidized program, that can be an exception. So for instance, a tenant lives in a public housing unit, they live there by themselves. 30% of their income is generally probably what they would pay for rent. Now they have someone else move in with them. That person is also working. That person's income is now going to get added to the household income, and their rent's going to get recalculated. And now it's going to be probably twice as much as it was before the person moved in, because now there's twice as much income. So that is a rent increase. That's could be more than 10%, but that doesn't trigger these protections, because it's due to essentially something the tenant has done to change their household composition, or the tenant has higher income, so now their rent goes up. Because if they live in a subsidized unit where their rent amount is tied to their income, which could mean their rent goes up if they are earning more income, but it could also mean their rent goes down if they lose income or become unemployed, then those aren't types of things that trigger the rent cap. And then the other part of this is that if a tenant lives in a building where the first certificate of occupancy was issued less than 15 years from the date of the notice of the rent increase, that is exempt. So essentially that is an exemption for like newly constructed buildings. So if someone's living in a building that was built in the past 15 years, essentially the landlord can charge them 30%, 40%, 100% rent increases. They're exempt from the cap, unfortunately. But I think that question that was asked, could a tenant have a claim against the landlord for increasing their rent because they believe it was retaliation for the tenant being engaged in some protected activity, or like having rental assistance, for example? That's possible. There's a law, ORS 9385, which is the law on retaliation, which basically says that if a tenant engages in certain protected activity, which could be like making a complaint to the landlord, or calling a housing inspector, or joining a tenant union, or testifying against the landlord in court. I don't know whether obtaining rental assistance would maybe fall in there, but maybe if the tenant had to dispute with their landlord about their right to use rental assistance and asserted their right to use it, and then the landlord in response increased their rent, the tenant would basically have to try to prove that the landlord had as a motive, at least as a motive, if not the motive, at least had a motive of retaliating against the tenant when they decided to implement the rent increase, which could be hard to prove, but but it is possible.
Thank you. So should we open it up for questions?
Sure. Yeah, sure.
If,
And
if folks just want to raise hands, we can, I'll try to keep track of who asks in what order. So Naveen, I see you have your hand up if you want to.
Yeah, I want to understand what's the difference between the first appearance and the trial. So is the first appearance, they just do like negotiation on what to pay or what is the plan, and the trial is where they prove that this negotiation has happened and either denied or approved. I really don't get the steps.
Sure. Leon, do you want to take that?
Yeah, so the first appearance is kind of two major things. It's the option to negotiate, to do a settlement, to come to some form of agreement. And the second part is really just scheduling. So if they do go to trial, planning when it will be, and having both parties agree on it. So also the landlord or the tenant doesn't have to, but they will be given the option to step out of the courtroom, see if they can come to some form of agreement, And then if not, then schedule for a trial. If that answers the question.
A little bit still, it's kind of confusing for me. I know it's simple in your guys' term, but for me it's new. So it's kind of confusing. So can they cannot like evict them after the first appearance. They have to go to the trial. And yeah, can they have more time to pay? Like the trial would be the last time for them to pay, right? The final. There's nothing afterwards. Okay.
Yeah, that's right. Like, so under HB 2001, so again, as long as the tenant has the actual payment, not a promissory note, but the actual payment for the money that's stated that is due in that termination notice that the landlord relied on and filed in the court case, and they give it to the landlord, it could be like in the middle of the trial before the trial is concluded, then the judge should basically say, okay, landlord, looks like here's the check for $1,000. You asked for $1,000. Your termination notice, you've been paid. I'm dismissing this case. But if you get to the end of trial and the judge says, yeah, tenant hasn't paid, this rental assistance doesn't come in, they said they were going to get here any minute, they're not here yet, this case is over, judgment for the landlord. At that point, when the judgment's entered for the landlord, that extinguishes, right, the protections there. Like, the tenant can't now come and say, well, judge, it's 5 minutes after you ruled against me, I have the check now, landlord, why can't the landlord just take it now and like vacate the judgment? The landlord could voluntarily agree to do that, but they don't have to. They don't have to do it. The protection only runs up until there's a judgment. And then also, just to be clear, so yeah, a tenant doesn't get evicted at the first appearance. There's no like hearing or evidence put on at the first appearance or trial at the first appearance. But what could happen is the tenant could enter into a stipulated agreement, and then if the tenant violates a stipulated agreement, they could be evicted without an official trial, because then they've waived their right to a trial. They've agreed not to go to trial. They've entered an agreement with the landlord. And then if the landlord says the tenant violates the agreement, then the landlord can get a judgment against the tenant without having a trial. Then the tenant on the back end can request a hearing on that, which is like a mini trial. It's basically limited just to what was in the agreement, what did the parties agree to within the four corners of the agreement, and did the tenant comply, or does the tenant have a defense for why they didn't comply? So it gets very limited. So it's important to know, because I've talked with tenants sometimes who say, well, yeah, I did a stipulated agreement, but before I signed it, I thought I would have had this defense that the landlord didn't properly serve me with the termination notice, or I didn't owe this much in rent, their ledger was wrong. All these defenses, it was retaliatory. They could have tons of defenses to the eviction case, but once you sign that stipulated agreement, you're basically essentially waiving those defenses. You're saying, I'm not going to go to trial, I'm not going to have these defenses, I'm going to enter into an agreement with the landlord, and everything that's going to be looked at from the court from there on out is going to be just that agreement. Yeah. So
okay, what if the landlord is refusing to give me the lease agreement or a ledger to get a rental assistance from somebody else? So what would be the case in this scenario? Because I have one of these cases, the landlord is installing, not giving me the rental agreement so I can help the tenant.
Yeah, so in those scenarios, I would say that basically the tenant has potentially a defense that the landlord's being uncooperative with the rental assistance provider. And then the tenant could go to trial, and then that would be a defense that they have to prove. They might need to ask you to come in or subpoena you to come in and testify about your interactions with the landlord, and have other documents or emails that they could verify and authenticate that show the landlord being obstinate and refusing to cooperate. Now, I think a court is going to have some outer limit on what's reasonable cooperation. And so I think things like a rental agreement, rent ledger, W-9, all that seems like very basic things that I would hope a court would say a landlord has to be cooperative with. But you could imagine a scenario where, maybe there's like a nonprofit that comes up with like a, 30-page rental assistance agreement document that they want the landlord to sign that indemnifies the nonprofit from liability and this or that or whatever. You could see maybe a court would say, well, landlords don't have to sign this 30-page document that's waiving all these rights or whatever. But I think, again, if it's like rental ledger, lease agreement, W-9, that all just seems like that's very easy for the landlord to provide. I would hope a court would say a landlord that's being difficult and obstinate in not providing that, is that could mean then the tenant has a defense to their case that the tenant has the burden to prove. It's not the landlord's burden to prove that they're being cooperative. It's the tenant's burden to prove the landlord's being uncooperative, basically.
I have one last question. I knew you have been through it and we're almost done with time. So the process from the termination notice served until the trial would take around 2 months?
For non-payment of rent cases, yeah, that's probably about, I'd say it's safe to say around 6 weeks to 8 weeks, I would say.
We had one question in the chat about how tenants' rights would be applied to somebody who does not have citizenship.
Well, so I would say, in general, someone's citizenship status doesn't and shouldn't make an impact on kind of their rights under Chapter 90, under federal fair housing law, for instance. There are certain types of federally subsidized programs, for instance, where there may be citizenship requirements. So for instance, in federally subsidized public housing, there is a rule that says there has to be at least one member of the household has to have some form of eligible citizenship or immigration status. So that could be someone that, like, say, is a lawful permanent resident, but you could not have a household where no one in that household didn't have some type of eligible status for that program. That could be a distinction or a difference for a tenant that does not have a particular type of immigration status or citizenship status. But in general, I mean, there are cases out there, and I think our office would probably take the position that landlords can't discriminate against someone on the basis of their citizenship status, because that essentially is discrimination based on someone's national origin, which is protected under federal and state fair housing law. And then there are some places like the city of Portland that go even further. There's the Portland Fair Ordinance actually explicitly says that landlords cannot demand that tenants provide citizenship or immigration related information as part of the application process, and that that landlords have to accept alternative forms of kind of proving identification. So in other words, a landlord can't say, well, everyone that rents from me has to give me their social security number. That would violate the Portland Fair Ordinance, and the tenant could potentially sue a landlord for violating that.
Okay, any other questions? We're out of time, but if folks want to hang on for a few minutes, Garrett seems game for that.
Sure, I'm happy to do so. Let me just mention real quick, I did find that bed bug brochure, which I can send to you, Natasha. But again, I'll just say briefly, it kind of depends on where you live. So this is a fact sheet, I think, that our office did a while ago. I don't think things have changed though. But so for instance, in Portland, if you live in a single family home and you have bed bugs, it's possible you might be responsible for the cost of the treatment. If you live in a multi-unit complex and you are the only unit that's infested, you might be responsible. You, the tenant, might be responsible for cost of the treatment. If more than one unit is infested in a multi-unit complex, then your landlord is responsible for the cost of the treatment. And that's all listed out in one of the Portland City codes. So in Portland City Ordinance. Gresham seems like it is a little bit different. It says, if you live in a single family home, you tenant may be responsible for cost of treatment. If you live in a multi-unit complex and the landlord can prove that you caused the bed bug infestation, you may be responsible for the cost of treatment. If more than one unit is infested in a multi-unit complex, your landlord is responsible. So again, it kind of depends on where. There may be city ordinances that apply that a tenant could look to depending on on their situation. But
great. Libby, do you want to go ahead with your question?
Yeah, hi. So I was wondering if somebody has epilepsy and they've been having, seizures that put them at risk for being on the second floor apartment. And also it's a thing about first responders being able to get to them in a way that if they have to be taken out on a stretcher, that it could impede, could be a dangerous situation for the family living on the second floor and this person suffering from epilepsy. And they've asked the landlord over and over again to put them in a first floor apartment. And the landlord has systematically rented a first floor apartment out to other tenants that are switching to a new apartment or to new applicants. Is there any sort of like legal repercussions that the tenant can go about like taking after that?
Yeah, Leon, do you want to take this one or?
Yeah, I could do some of it. I mean, I think as a basis, they could file a hot or bully complaint and start with there, which would open an investigation. I think also Fair Housing Council is a good place to start. And I know that they have advocates who can give some information. I think also an important part would be how they've been requesting the reasonable accommodation. So if you have documentation that it's been in writing, that's really helpful to show a pattern of it being continuously refused. And yeah, Garrett, do you have anything to add?
No, yeah, I mean, I'll just say, like, I don't know if I've heard this particular situation before, but certainly, that's pretty common for tenants with different types of disabilities to request being on a ground floor unit. And I think generally, I think I would say if there's any type of disability related reason why being on a first floor unit is safer or is better for the tenant or is going to be more appropriate for them given their disability, whatever that disability is, I don't see a landlord likely escaping liability. If indeed there are first floor units that are becoming available, and then the landlord is refusing to rent it. What we see sometimes is that buildings where just the first floor units just aren't coming up, and in that scenario, a landlord doesn't have to, for instance, like evict a tenant from a first floor unit to allow the other tenant with the accommodation request to move in there. But yes, like once the unit becomes available, I mean, the other bit of caution I would just say is, again, probably like, looking at things in the picture of, is the unit that the tenant's moving from basically the same or similar to the unit that they would be occupying, right? So if the tenant lives in a studio apartment, but all the first floor units are 4-bedroom units, then maybe the landlord doesn't have an obligation. The tenant wants to pay the same rent as a studio and move into a 4-bedroom. That could, I could see a court saying, well, that's an undue financial burden on the landlord. They have to lose this rent money they otherwise would have had. But if it's like a similar unit, rent's about the same, I would imagine, yeah. And again, if the tenant can prove that there have been other units that become vacant and the landlord is just filling them with other folks. And again, kind of the assumption would be that other folks that, potentially if there had to be evidence, don't also have reasonable accommodation requests to move from another floor, then I would think there would be a good chance, yeah, landlord could be held liable for failing to accommodate the resident. The other option too with some of these situations is that I have talked with tenants about is sometimes exploring, if it's a landlord or property manager that has other properties, exploring whether there may be possibly of a transfer to a ground floor unit at another building.
Sorry, can you please send me I wrote in the chat the bed bugs document that you said about, because I face bed bugs in my work a lot. Like this situation comes up in my work a lot.
I will plan to share out the slides, the link to the recorded conversation, and the bed bug information sheet, and maybe anything else that comes up between us after that time, with all of the IDD case managers and all of the personal agents that typically get information sent from me. If you do not fall into that category and you happen to be at this training for some other reason, please drop your email in the chat and I will include you in the information disbursement.